Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Law of Torts, we were discussing general defenses against tortious liability, and in that series, this is my 8th video where we are going to understand the 7th general defense, that is necessity. Yes, the first video was introduction video where we understood all the general defenses available. So in my next slide, I'll quickly show all of them, and the second slide will be the quick slide on necessity which we have already discussed in the intro session, and thereafter we'll understand what is necessity, and then we'll understand the difference between necessity, private defense and inevitable accident, and then few very interesting case laws on necessity. Let's quickly get into the first slide. Yeah, this is a list of general defenses against tortious liability starting from voluntary non-fit injuria, plaintiff the wrongdoer, inevitable accident, act of God, private defense, mistake, necessity, statutory authority, act of the state, parent having parental or quasi-parental authority, and acts causing slight harm. This slide also we have already seen in the intro session, and this is the 7th general defense that we are discussing, that is necessity. I have already told that necessity knows no law. Like for example, if a surgery is done without the consent of the patient to save his life, that is necessity, because if doctor keeps on thinking about consent and if the patient is not conscious in the process of taking consent, the patient might die. So to save him without the consent of the patient, the doctor can still do surgery, that is necessity. Likewise, if somebody is throwing some goods from the ship to protect the ship from sinking and to save the life of human being, that is also fine, because that is to avoid greater harm, that is also coming under necessity. Likewise, if there are series of houses and one house has got fire, and to avoid other houses catching fire, if somebody is breaking the bridge by removing one of the huts in between, that is also considered as necessity, because otherwise there will be greater harm. In all these scenarios, to avoid greater harm, if somebody is taking an action, that will become a general defense under law of tort. To understand this in detail, we have to take the help of case laws and stuffs like that, which we will do in my later slides. The legal maxim says necessitas non habet legem, which means necessity knows no law. To avoid greater harm or to prevent some greater harm, if some act is done by the defendant, that will be considered as general defense under law of tort. Yes, I have already explained 3 illustrations which I have elaborated here also, and then we need to understand the difference between necessity, private defense and inevitable accident. Necessity is done to avoid or to prevent greater harm, whereas in private defense what happens, the plaintiff has caused some danger to your body or your property, or someone else's body or someone else's property, and to avoid that, if you are doing something, that is private defense. In inevitable accident what happens, something happens in spite of you are taking care so much, or you have done every efforts to avoid something happening, but even then if something is happening, that is inevitable accident. In necessity what happens, purposefully you are doing something to prevent greater harm, whereas in inevitable accident you have done your best to avoid something happening, but even then that has happened, that is inevitable accident. I hope those concepts are very clear. With that, I am taking you to case laws. Just to sum up, to prevent from some greater harm or to avoid some greater harm, if the defendant has done something, that is a very good general defense available under law of tort. The first case law that we are discussing here is Cope versus Sharpe. This is a very easy case law where there was a land which got fire. So the defendant, who is a servant of a particular person, he tried to avoid the fire by trespassing the plaintiff's property, and he successfully stopped the fire from spreading. Now the plaintiff put a case against the defendant saying that the defendant has trespassed, but however the court said that to prevent greater harm, whatever defendant has done is a very good general defense available with him, and hence it is not a tort. That is what decided under Cope versus Sharpe. The second case law is Lee versus Gladstone. Here what happened? A particular person has gone on hunger strike. Okay, he was in jail and he gone on hunger strike. Now the jail authority or the prison authority forcefully made him to eat. Why did they do so? Because they wanted to protect the life of the person who has gone on hunger strike. Now it was in this case law held that since the crown had the duty to preserve the lives and health of the prisoners, it is okay to do so. Otherwise, the prisoner would have died. So, to prevent from the greater harm, whatever action is done by the jailer or the people there, it is okay, which is what held by the court. To the extent of necessity, this case law is sufficient, but if you are curious as to whether this is the last judgment regarding this or there are some progress, definitely there are progress. Remember, Lee versus Gladstone judgment came in the year 1909. After almost 9 decades, there was one more ruling came in the case law of Secretary of State for the Home Department versus Sharpe, where the judgment gone other way. It was vice versa comparing to Lee versus Gladstone. Just for your information, I have given the case law here also. If you are interested to know the facts, I have given few of them. Please go through them by pausing the video. One very important aspect that you need to remember here when we are discussing necessity is defendant will not succeed all the time. Sometime defendant might fail also, and for that I have 3 very interesting case laws. The first one is Carter versus Thomas. Now what happened here? There was a fire incident at plaintiff's place and he called the firemen and they were already there in the scene. Now defendant saw the fire incident and in a good faith to help the plaintiff and the fire extinguishing team, he also joined them. Now plaintiff put a case saying that the defendant has done trespass, he has entered my property without my consent, so he put a case against the defendant. And the court said, as there were already firemen available, as they were already taking care of the things and they were trying to take things under their control, it was not necessary from the angle of defendant to enter plaintiff's property without his consent. So the judgment gone against the defendant and he couldn't take the general defense of necessity. That is what we have to observe in Carter versus Thomas case law. Before getting into the next case law, you should always remember that it is very important to justify the act when you are taking necessity as a defense. The classic case for that is Kick versus Gregory. What happened here? A person dead. We'll call him as A. Now A is dead. There are so many people and there were few jewelry of the dead person, that is A's jewelries were there. Now A's sister-in-law came to the scene and looking at the dead body, she felt the jewelries are not safe and she has taken those jewelries and kept it somewhere. Now those jewelries which were being kept by the sister-in-law of A were being stolen by someone. Now the case came to the court and here in the court, A's sister-in-law couldn't convince the court that why it was necessary from her side to remove all those jewels and keep it in a particular place. She couldn't convince logically to the court, right? She failed and hence her attempt of taking general defense of necessity was also failed. So this is a very important part that you should always keep in your mind, that there should be sufficient justification from the defendant to prove that whatever is done by him or her was necessary to prevent the greater harm. The last case law that we are discussing here is the Queen versus Dudley and Stephens. Now this case law we have already discussed under private defense also. What happened here? 3 people got stuck in a boat in the mid-sea and one among them was a small boy. Now Dudley and Stephens, because they were all starving, they decided that we will kill this boy and eat him to protect ourselves. They killed the boy and ate him and they survived and came back. Now in the court they said to protect ourselves we have done this. But the court said this is not an act of private defense. The boy has not caused any danger to you, right? So you cannot say this as private defense, and neither it is necessity, because to protect yourself, if somebody is not causing any danger, even then if you are killing them, that will not be considered as necessity. Okay, you might say we were too, otherwise we would have died, so to prevent that we have eaten that. All of that stuff will not work. To protect yourself unnecessarily, you cannot kill any human being, right? That is not allowed, which is what held in this case law. Just like to avoid hungry, stealing bread is not justified. Okay, if that is justified, then what happens? Nobody would work, everybody starts stealing, right? That is not allowed under law of tort. That is not necessity. For our necessity, we have to work, we have to earn, and we have to eat. And only to avoid greater harms, like whatever illustrations I have given, whatever the earlier case laws that I have discussed, under those situations, it will be utilized by the defendant as general defense. I hope that is very clear. With that thinking, I am handing over this presentation to Nishan.
Our mind is like a computer. When we sleep, it shuts down. When we wake up, it starts working again. By the way, my mind is working. Is your mind working? With that, I am concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.